Greetings to all the participants. We will give a couple of minutes more for the others to join in. So we'll keep you posted. We'll start in next couple of minutes, please. Thank you. Okay, I think we are good to start the session. So first of all, greetings to all the participants and thank you for joining us for this session. I think at the onset, on behalf of Khaitan and all our panelists over here, we wish all of you are safe and healthy, and we do hope that we come out of this crisis saner, wiser, and more resolute to avoid and at least such crisis in the future. And I think we do hope there's a lot more positive things to look for as we get out of this crisis. And we do hope all of you, your near ones and dear ones, stay safe. So I think the topic that we're going to cover today is relating to the impact of the new press note, which was announced by the government of India on April 17th. And more importantly, I think the impact of that, especially for investors coming from China. Now, just to provide you a quick backdrop to the issue at hand, and I think the government, I think, had come out with this press note in the backdrop of the pandemic, which obviously has created a significant amount of economic turmoil. And to that extent, the government had obviously felt the need, and I think the threat that the government was trying to avoid as part of this amendment to the FDI policy was a situation where opportunistic hostile takeover of businesses at valuations which obviously are stressed today. And to that extent, the government felt the need to essentially get better control over the flow of capitals and especially also look at more control transactions which may be coming from certain jurisdictions that the government felt were sensitive. And as a part of that, they undertook the review of the FDI policy, and as a part of the amendment to the FDI policy, they issued the press note 3, which is what we're going to kind of talk about in a bit more detail. I think what is also important, I think, for the audience here, this is part of the exercise where the government felt that while the FDI as India has evolved significantly over the years to bring most of the sectors for FDI under the automatic route, it felt the need to at least put some controls, especially in these times, to essentially ensure that there is better monitoring of capital flow coming in, and also for certain sensitive jurisdictions, which have been identified by the press note 3 as those countries which share the land border with India. Uh, those countries are essentially going to be requiring, they have been kind of disqualified to an extent to go under the automatic route, and such FDI where the beneficial owner is within any of these jurisdictions will be required to take a prior approval of the government. Also, I think today, at least as the press note where we cover in the session, does not clearly spell out or differentiate between whether it's a majority control, minority, active investment or passive investment. So I think today, at least the policy wording is broad to cover any form of beneficial ownership from the list of these restricted jurisdictions would be required to go through the approval route. Parallelly, I think there's also a separate exercise being undertaken by the regulators to from a FPI, the portfolio investment side. And again, it's not to cause any alarm at this point because the current press note does not obviously extend to some of the other regime, and I'll come to that shortly. But as a part of a set exercise, I think we've been told that SEBI, which is the Securities and Exchange Board of India, is undertaking its own exercise to kind of assess and understand the capital flows from different jurisdictions, including those which would be covered as a part of the restricted jurisdictions here. But that again is something for a topic which we can cover it separately, as that's something which is still in the pipeline. What is important, as I mentioned over here, the current press note essentially applies to foreign direct investment. And I'll just come to the different forms of investment regime shortly. But to make it easier for you, this only applies to FDI investments and does not essentially apply to a lot of other form of foreign investments, as we'll come to that. The second part of it is the applicability of this press note, as the general policy also contains, is prospective. So to that extent, whatever investment which has already come in, including from the restricted jurisdictions, does not get impacted. But there are nuances which I think our other panelists will cover as we go along. And of course, it does not today apply to a lot of other companies, including foreign Indian-owned and controlled enterprises, and I think which as a part of the discussion we'll cover, and there are specific questions that we've been receiving on that, so we'll cover that as well as we go through the discussion. I think just before I hand it over to the other, and I think this would serve as a good backdrop for people who may not be fully familiar with the regime. So, as many of you know, India today, while it has moved to a complete current account convertibility when it comes to capital account, we still do have restrictions on the capital account transactions for foreign residents. And as part of that condition, I think there are identified routes under which the foreign investment have been permitted to invest. And these are essentially 5 broad framework rules and regulations governing foreign investment, starting with FDI, which is really an omnibus regime for any foreign investor looking at investing in India. And it covers all forms of investment, which could be minority, control, or any other, even private equity to that extent. And it is essentially, and there the route available for foreign investors subject to certain sectoral caps or restrictions is either automatic or approval route. And this is what gets impacted by the press note 3, and where while most sectors over the years have been moved to the automatic route, I think the new press note brings in certain restrictions on certain types of investments. But otherwise, I think in terms of instruments, it basically allows any equity or compulsorily convertible instruments to be covered as a part of it. And to that extent, from a exit and entry perspective, there are certain pricing restrictions which apply. Um, and then there are other routes, which is FPI, which is the foreign portfolio investment route, which is primarily with respect to those looking at investing on the capital markets or taking minority interest, and this is capped at 10% of the paid up capital of a company. It is KYC based, pretty much put on an automatic route now with the DDPs approving any license. And then you have the route of FVCI, which is primarily for private equity investors, foreign venture capital investors. Today, that route is limited to only 10 identified sectors which are covered, and also startups are allowed to be invested through the FVCI. So while a very flexible route, because it does away with a lot of restriction on pricing, exit restrictions for FDI, but it has limited applicability to those 10 sectors. And then you have the alternative investment fund route, which is onshore private equity and other investment managers can set up AIFs in India, and such AIFs have been allowed to accept foreign contribution as well, and they would then be able to make downstream investments. There are, of course, nuances to that, but as we go along, we'll cover that in part of our session. And lastly is the ECB, which is the external commercial borrowing route, which is more for debt, foreign debt coming in. Again, that does not get impacted directly by the press note, but again, there will be some implications of this press note, especially in situations where you are converting loan, or maybe at the time when you are enforcing some of the security interests. We will see how this gets impacted. So I think that's the broad landscape. I think with that, I would like to call upon and invite Karthik to kind of take us through the other relevant sections of the presentation, as well as what are the key considerations that Chinese investors more specifically need to bear in mind. Over to you, Karthik.
Thank you, Sid. I hope everyone can hear me clearly.
Karthik, please go ahead.
Yeah, thank you. Just want to move the slides just a bit.
Hi, just double tap on the screen, presentation screen.
Sure.
Siddhartha, can you please move the next slide?
Actually, could you move the next slide, please?
I will try to do that. Give me 1 second. I think there's, okay, sure, I think that maybe, so why don't we go ahead, Karthik? I think we'll try and resolve this, but maybe you want to.
Sure. Thank you. I think it's working now. Thanks, everybody.
Yeah.
Just by way of background, I think mostly the key focus area for Chinese investments into India so far, they've mostly been on the tech side. And obviously, we've seen a fair amount of recent interest in manufacturing, renewables. But I think it's just a very fair statement to make that it's really been on the technology, e-commerce, startup side where we've seen the maximum amount of Chinese investments coming in. Unfortunately, as Siddharth mentioned, the press note is agnostic. It does not take into account what sector you're investing in, what size of investment you are investing in. It applies to all FDI transactions, irrespective of size and sectors. And of course, that's one of the reasons why there's a lot of representations and a lot of talk going on with the government, because a lot of startup investors, a lot of early stage VC investors, they believe that just having Chinese investments in this ecosystem without prior approvals makes deals faster, provides more liquidity, provides more honest valuations. So that's an ongoing discussion with the government, and I can tell you more about what discussions are on and what feedback we're getting as we proceed with this. I think one of the most key questions we're getting right now with press note 3 is what happens with existing investments. On existing investments, I just want to cast aside any doubts. There is no grandfather. There is full grandfathering. You don't have to go back to the government and get prior approvals for your existing stake. The issue which is now coming up is what happens with further capital infusions. Do those require prior approval? On an absolute technical reading of the press note, yes, the answer is any new capital infusions, even if you are an existing investor, even if it is pursuant to a contract under which you had preemptive rights, any new inflow and primary infusion now requires government approval. So that's one thing to keep in mind. Of course, there is some hope that the government may say, look, as long as you're keeping your percentage stake at the same level, you are coming in with your proportionate share so that your percentage beneficial ownership is not increasing. You don't need any prior approval. That's a hope which we have, and that's something the government is actively considering and for which, again, representations are being made. But as of now, even if you had to come in at a rights issuance to maintain your primary stake at the level you are at, that too requires government approval. And the same goes for any contractual terms. So, for example, if you had a right of first refusal, and under the right of first refusal, you had a right to buy a co-investor or the founder out. Under those terms as well, to exercise your right of first refusal, you don't need approval. But to, of course, consummate your right of first refusal now, you will need prior approval, because although you had a contractual right to exercise your right of first refusal, to consummate it and increase your FDI stake in the company, it will come under the ambit of the press note. On exits, this is again something we've got a lot of questions on. What happens in case I want to sell down my stake? The press note is very clear. It only applies on a going forward basis. It only applies to new investments. And the interpretation on that is frankly helpful, because it allows you to reach the conclusion, look, if I'm doing a sell down, whether it's on a secondary basis to another buyer, whether I am doing it via an IPO, again, there is no requirement for any prior approval, because this is not a fresh investment. Of course, in a secondary, the issue could come, what if I'm selling to another Chinese buyer? What if I'm selling it to a fund where the majority LPs are Chinese LPs? What happens in those circumstances? In those circumstances, I think the safe view to take for the time being is that we will need an approval for only that class of secondary buyers. Otherwise, secondary to the larger world, there is really no concern at this point in time. On PN3, just a couple of items on the exclusions that mentioned. So if I'm an Indian owned and controlled company with foreign investment, let's say the definition of Indian owned and controlled company is 51% Indian shareholding, majority of the board is Indian directors. In that case, if that company, which we call for simplicity an IOCC, that makes any downstream investments in India, that buys other companies in India, even though it has beneficial Chinese ownership in the IOCC itself, those downstream acquisitions, those M&A activities in India will not require any prior approvals because of a quirk in our FDI policy. Our FDI policy says that, look, any downstream investments, any acquisitions made by an IOCC of other Indian companies, it will be regarded as Indian investment and not FDI. And these rule changes are all under FDI. So these rule changes will not apply to a company which still qualifies as an Indian owned and controlled company. But on the other hand, if you had, let's say, a Chinese company had a subsidiary in India, 100% owned subsidiary, or what you call a WOFI or WOS, if that subsidiary were to undertake M&A in India by other companies in India, that subsidiary would require prior approvals, because the minute it buys the target company, in the target company, Chinese ownership is directly or indirectly increasing on a beneficial ownership basis. I mean, obviously, people are looking at some structures around it. So, for example, if you were to do a business transfer, if you were to do an asset purchase, if you were to do a slump sale using your company in India, that would not require any prior approvals. Just one second, I'll move to the next slides. Sid, do you want to just take the next slide? Sid, you want to take the next slide? On beneficial ownership.
I think in respect of one of the key, sorry, am I audible? Karthik, am I audible?
Yeah, you're audible. If you can just go to the slide on beneficial ownership.
Yeah, I think you probably have to. Okay, so I think maybe while we get the slide back on for that's the one. Okay, so I think one of the key confusion and I think the biggest kind of question that exists out of the press note 3 is really a reference to the term beneficial ownership. Now, if you the press note 3 has effectively said that if you have a beneficial owner of an Indian enterprise, which is from any of these kind of restricted jurisdictions, then to that extent, you will be required to take a prior approval of the government. Unfortunately, the press note itself has not defined the concept of a beneficial owner. Now, there are obviously, having said that, there are different definitions of a beneficial ownership which have been covered as a part of what we call the Prevention of Money Laundering Act, which is a more generic regulations governing any issues surrounding money laundering and also equally applies to KYC requirements. And then there's also a definition of a substantial beneficial owner, which is under the Companies Act. Now, the question that arises is obviously the thresholds under each of these provisions are slightly different. So when it comes to PMLA, the basic rule is that the beneficial owner will be determined in cases where a person or an individual is owning more than 25% interest in case of a corporate vehicle. And in case of non-corporate vehicles, this threshold comes down to 15%. So it obviously has a much kind of wider definition, and the purpose out there is to really determine who's the ultimate beneficial owner. So you keep looking up through the chain to determine who's the ultimate beneficial owner. So that's the test under PMLA. It also has an element of, so if you don't have anyone who is essentially breaching that cap, then it also applies the control test to determine who is the beneficial owner under the PMLA. So you have both these tests based on which you identify a ultimate beneficial owner. On the other hand, the company law also introduced the concept of a substantial beneficial owner. And there the threshold to determine who's an SBO starts with a 10% ownership. And as per the current provision, so you essentially apply the test at an entity level, identify who is more than 10% shareholder, and then you keep applying the test to who is in control or is a significant beneficiary to that entity. And then you ultimately identify one individual who is effectively seen to be in control. So the confusion because of lack of direct reference to how the beneficial ownership will be determined under the press note 3 is which are the thresholds that one needs to use to the beneficial owner definition. So that has been one of the key issue that the government and I think needs to clarify. There's a lot of representation which is being made around this, including especially for pooled investment vehicle, and I think that is the other segment of investor who are likely to be impacted as to whether the same threshold of PMLA or a Companies Act substantial beneficial owner will apply, or should there be a different test. So the current representations which are being made that for pooled investment vehicle, if the intent is to really control, is to avoid hostile acquisitions and takeover, then in a pooled investment vehicle, a threshold of 25% to an LP should be a reasonable threshold for the to look at. As anything below that would not give LP a desired control, and hence it should not be seen to be going against the intent of the press note. So I think that's really one area where I think there is still an ongoing representation happening, and we will see some clarity emerge out of it over the next couple of weeks. And the only additional point I think has been the status for Hong Kong, and I think that is really the other debate, because the argument in favor of treating Hong Kong as a different jurisdiction from China is really because India has recognized in many instances Hong Kong as a separate and a special administrative region, independent of China. And to give the example, India has a separate tax treaty which it has entered into with Hong Kong, while it also has a treaty with China. So that clearly indicates that for certain sovereign purpose, India has treated Hong Kong differently. Similarly, for WTO agreement, I think Hong Kong has been treated as a separate jurisdiction. Having said that, I think the current scheme of thinking seems to be that they may still continue to see Hong Kong as a part of PRC unless a strong representation and convincing is done with the government that there is a need to look at the Hong Kong jurisdiction different from China with whatever additional scrutiny that may be required. I think for especially for fund managers, that would be a very significant issue. A lot of Asia Pac fund managers are based out of Hong Kong. And the definition under Press Note 3 not only refers to the beneficial ownership being in this jurisdiction, but in case of it, if it is situated, so even a location of a beneficial owner or a controlling person is in any of these restricted jurisdiction would get covered. So I think that's an area where I think things will evolve over the next few weeks. But yes, as lawyers, I think, and firms, people are taking certain view on this. And as we go along with our Q&A as well as the other part of the session, we will of course cover that as well. Back to you, Karthik.
Thank you. And actually, one of the reasons why these representations are being made is because the press note is absolutely vague on what constitutes beneficial ownership. Even a 1% Chinese shareholding in a company or a 1% holding in a pooled investment vehicle by Chinese LPs would qualify it as beneficial ownership for the purpose of the press note, which is why all these tests are being advocated. I think on beneficial ownership, I think I would say watch this space. Next week, definitely, we are expecting a number of clarifications coming from the government. And these are not just Chinese companies making representations. These are large industry bodies, private equity associations, which are making representations, just given the fact how many large global capital pools have Asia-dedicated funds with Chinese LPs. This one is something Siddharth briefly touched upon. This is on the key question is treatment of Hong Kong. Like India has a separate tax treaty with Hong Kong, separate WTO agreement with Hong Kong. In fact, for court and arbitration awards, we have a separate protocol with Hong Kong where Hong Kong court awards, Hong Kong arbitration awards are enforceable in India as if they were Indian court decrees or Indian arbitral awards. We don't have a similar framework with China. So obviously, there's a strong argument that, look, you should be treating Hong Kong separate from China for these purposes. I'm not 100% sure whether which way the government will lead on this. I mean, there is some talk from the government that, look, we may do more KYC or a higher testing for ultimate beneficial ownership from Hong Kong. But on beneficial ownership, I think we are fairly confident we will see some clarification in one way or the other. On the distinction between China and Hong Kong, I would say jury's still out, and you need to keep a close eye on this. And if you do have to keep a close eye out on this, I would say start looking at your current funds. See what is the LP concentration there. How heavily are they from China? Can you make an argument that, let's say, 10% or 25% of significant beneficial owners in my funds are not from the PRC, etc.? I think if those arguments are possible, that even having a Hong Kong manager per se may allow you to argue that, look, my investments into India do not require any prior approval. We briefly touched upon what happens if a Chinese-owned company in India makes downstream acquisitions. And I think it's a fair conclusion there that you have to take a view that any downstream investments made by a wholly owned subsidiary of a Chinese company in India, even those an Indian company, requires prior approvals. I think on the approval route, I think people should just keep in mind that, look, India is not saying that we don't want Chinese investments. But that's not the purpose of the press note. I think the purpose of the press note is for the government to say, we want to monitor capital flows better. We want better oversight. We want to understand what sectors are sensitive, what sectors are not sensitive, and accordingly facilitate investments. So I think that's my number one takeaway from the press note. I think there was some initial hysteria when the press note came around saying that, look, Chinese investments are not welcome, etc., etc. That's not the case. It's just a filter of approval, which hopefully they'll make more efficient. And like any approval process, a bit of some strong arguments will have to be weaved in: employment potential, minimum capex potential, complete transparency with the government around beneficial ownership, a clear attestation to what our long-term plans for India are. How do we think the synergies are? Uh, you know, in terms of proposals, be transparent upfront in terms of royalty rates, in terms of transfer pricing benefits, etc. I think once those are all part of an approval package, I personally don't see approvals in what you would call sensitive or non-sensitive sectors such as, let's say, manufacturing or tech or e-commerce to take more than, I would say, between 8 to 12 weeks. But unless the government comes up with a fast track process, I think 8 to 12 weeks is a good thumb rule to expect in planning for any going forward approvals. I think this is on just planning ahead. I think one point is if can you check your transaction structures to see if you can save on the approval timeline. For example, under the new policy, if you invest in an AIF and the AIF is Indian controlled and managed, those downstream investments by the AIF will not require any prior approvals. And we've seen some strategic investors do that in India before, where they've tied up with a local fund manager, invested in that particular fund, and because the fund is deemed to have been managed and controlled by an Indian manager, any downstream investments have not required prior approvals. So that's one structuring piece to keep in mind. Where it's possible and it's not too complicated, I think business transfers, asset purchases, employee transfers from the Indian target to existing businesses or to existing Chinese-owned subsidiaries, that is something which should be borne in mind. The only item I would highlight there is that, look, if you have to put more capital into your wholly owned subsidiary so that it can undertake a business acquisition in India, that infusion of capital will again require prior approval because it will result in an increase in beneficial ownership. So that's a watch out item. But again, there could be some ways around this. For example, overseas lending to a wholly owned subsidiary of a Chinese company does not require any prior approvals. Similarly, onshore lending, let's say by an ICBC branch in Mumbai or a Bank of China branch in Delhi to an onshore wholly owned subsidiary of a Chinese company, that doesn't require approvals again. If a parent wants to give shareholder loans to its Indian subsidiary, again, that does not require prior approvals because shareholder loans are not infusion of capital for the purposes of FDI. In fact, there's a separate exemption given for them under the form of ECB, external commercial borrowings. So again, while you're considering investments, and if there's a real liquidity crunch or there's immediate funding requirement, there could be ways and means around this where you don't have to wait for the approval process for the equity to come in. And of course, some of them have their quirks as well. For example, if you're giving a shareholder loan to your Indian subsidiary, the debt equity ratio cannot exceed 7:1. So of course, you have to see whether it's one size fits all, or how does this particular structure work for my short-term capital needs in India. I think I can see that there are a lot of global M&A practitioners on this call. I think one item I should alert you up front is that assume for a minute there's an offshore target. Let's say it's a European target with an Indian subsidiary. Under these new rules, because any Chinese acquisition of the European target will result in an increase in Chinese beneficial ownership in the Indian subsidiary of the European target, the entire transaction will now become subject to prior approval, even though the transaction was being consummated offshore and there was no movement of Indian shares. This is because the logic which will apply is that there's an Indian subsidiary, there's been a direct or indirect increase in its beneficial Chinese ownership by virtue of the acquisition of the European target. So again, when you're structuring global deals, you'll have to factor India into this, and this kind of factoring could take different forms. Actually, budget for some time for approvals. You may want to budget some time for, look, if the approval is not coming on time, should I just divest this business? Or maybe just consider a whole separate provision saying that, look, before we undertake this transaction, We don't want to, it's a quick and fast transaction. We don't want to wait for India approvals. So let's divest this India subsidiary of first and subsequently merge this back or get it part of the into the transaction perimeter and avoid an upfront approval. So again, it will require some planning in any transactions with a large global leg. I mean, so far people only used to take antitrust into account, but you'll have to take this one piece about India leg into account as well when you start planning a transaction at a global level. I think we've discussed a few of these. There's one structure called FVCI, the Foreign Venture Capital Investor Route. It's not been very popular for investors from China, but a lot of Hong Kong fund managers have a FVCI registration. If you are making the investments under the FVCI route, again, same like FPI, you don't need any prior approvals. You can go in and out as you please without prior approvals. The only catch is FVCI can only be used for 10 sectors. It's a broad range of sectors. It includes infrastructure, it includes biotech, it includes IT hardware, IT software. But at the same time, if you have a transaction which is not falling within those FVCI parameters, for example, financial services, in that case, that route of cost can't be used. And like I said, not everybody has an FVCI registration. Very common for a number of Hong Kong fund managers to have an FVCI registration. So even if those managers can't do a transaction under the FDI route because of the prior approval requirement, but if their target falls in one of the 10 FVCI sectors, there won't be a problem for them to go in and out without prior approvals if they decide to utilize the FVCI structure. Guys, actually, I'll stop the slides now. We have a number of questions and we won't be able to do justice to them if we don't wrap up now. Sid, do you want to just start picking those questions?
I think thank you. Thanks, Karthik, for giving a very comprehensive overview. And I think you are right. I think this is a topic which is obviously attracting a lot of questions around the world. And I think it would be only be fair to kind of try and cover as many of those, and we will try to do that. So I think before I the first question, honestly, and that's where I wanted to bring in our partner, Atul, regulatory partner Atul, who has been in the things with the regulators and in consultations that are ongoing. So Atul, what I actually wanted to start off with you to kind of first the question that we have, and I think a lot of our clients have been asking, while we talked about what happens to those entities. So there is a wholly owned subsidiary, and I think Karthik did allude to that, which basically are existing and already under the control of a Chinese investor. Would they be covered within the ambit? Has there been any thought process with the government as to how they would deal with those situations? I mean, any insight on that would be very helpful.
Thanks, Ed. So yes, in relation to those companies where there is already a Chinese investment, either in form of a majority control or say such Indian entities are 100% wholly owned by the Chinese investors, in such cases, for any further fundraising or any further infusion, obviously approval would be required. But if we go by the language of the press note as well as FEMA notification, the idea of issuing this press note is to prevent any hostile takeover. And obviously, in case of companies which are already under Chinese control, or those companies which are 100% wholly owned subsidiaries of Chinese investments, either directly or indirectly, in those cases, the approval mechanism would be fast tracked. Government would kind of look at it in a different manner vis-a-vis sensitive sectors as well as hostile takeovers. And there, the sense which I am getting from the government is that approval would be fast tracked, and it should come within 2.5 months.
Okay. No, I think that's helpful, because I think one of the questions also from the audience is that what happens for these entities as they kind of need additional capital infusion, and because there's no question of change of control there. So I think this is helpful. But also I think related to that, Atul, we also think that what about global M&As? And more importantly, situations where you are, well, there is no direct change in ownership of the Indian entities, but say, an offshore holding company getting acquired globally by, say, a Chinese company, and how would those be kind of seen by the government as a part of the current policy? Would that
Yeah, so
kind of again by press note?
yeah, even in case of a global M&A with an India leg or an Indian subsidiary involved in that entire transaction structure, then that would require approval, considering the language of the FEMA notification is such that any direct or indirect change in control when a Chinese investor is having either a equity stake or a beneficial interest, that would require prior government approval. So to answer to your query, even in a global M&A transaction, if a Chinese investor is acquiring shares of say a German company which is having a subsidiary in Mauritius, and that Mauritius entity has then a subsidiary in India, that transaction would require approval from the government in the present scenario.
And I think this is interesting because so far, at least the view under the FDI, because there was no direct reference to a direct, indirect, or beneficial ownership. So a lot of transactions which were effectively happening at an offshore level, and there was, say, an indirect transfer of ownership. And we've seen that in case of, say, real estate and a lot of others, where the lock-ins used to be there for FDI, but when it happened at an offshore level, transactions were not getting captured within the ambit of the FDI policy. And I think the new language seems to now extend it beyond the immediate holder. And I think that would be a very important consideration, especially where for global acquisitions, where you may have to now factor this in as an approval process. So I think this is something which is a deviation from what we had seen the FDI policy applying earlier. I think just coming to a set of question, I think, and maybe Karthik, I'll probably come to you on this one. I think the question is, in some sense, that subsequent to the change in the FDI policy, which came through the FEMA notification on April 22nd, an amendment was brought to the Regulation 6A. Now, the question from one of the participants is, because 6A deals with investments in general, would that not cover other forms of foreign investments, including FPI, FDI, or FECI? I mean, that's one of the questions that's coming in. Maybe Atul or Karthik, one of you want to take it?
Well, absolutely. So, the way the government did the amendment, it was very surgical. It was made to Section 6A of the FEMA. It didn't apply, and the way the FEMA applies is that there's 6A, which applies to FDI investments. There's 6C, which applies to investments made into AIFs. The 6B, which applies to investments made under the FPI route. So by amending 6A, they only made a change on the foreign direct investment route. They did not touch investments, let's say, made under the FPI route. They didn't touch investments which are made under the FECI route. They didn't touch investments which are made into AIFs and then downstream investments made by the AIF. So they had the pen in their hands and they drafted the policy. And this notification was issued by them after the press note. So they had time to consider the law after the press note was issued as well. So at least it betrays the general thinking that, look, they've thought through this, and they have, for now, the prior approval requirement only applies to the FDI route and no other route for the time being. So I mean,
right.
we're hearing that, look, under the FPI route, there may be, which is the foreign portfolio route, there may be better there may be higher increased monitoring, they may be more careful about granting new licenses, etc. But that's a separate story. As far as the regulations are concerned, it's just FDI for the time being, and all other investment routes into India are what they are. This new rule doesn't change any of that.
No, that's right, and I think that's how also we, in our several engagements with the policymakers, regulators, that's come out pretty clearly that the current threshold does not essentially extend to any other form of foreign investment. And obviously, even if they want to extend it to FPI, I think the mechanism for that will have to be thought through differently, because FPI may also allow investments on the market and stock exchanges, And there, at some level, the recipient entity may not have the opportunity to control that investment, and hence I don't think the current mechanism would technically work in some sense for listed investments, especially under the FPI. I think one question, Atul, for you, I think from the participant is, do an individual seller need to also take permission for a secondary sale of equity in a startup, along with a primary sale to a Chinese investor, or can it be covered as a part of a total permission taken by the company?
So even so, if we go by the notification, FEMA notification, it talks about person situated in India, even a citizen as well as entity. So, so to answer to this question, even an individual would be covered. And if an individual is acquiring a stake at any level, who is a Chinese individual, then that would require permission.
Okay. And I think just to add, if I don't know if this is answering your question, but today, at least from our experience of approval route, if these are simultaneous transactions, and again, today the regulator would say that you cannot apply for a composite approval. So if suppose there is a primary and a secondary transaction happening simultaneously, there is no requirement for the entity to go for two separate approvals. You can cover it as a approval. And I think that is how, and even otherwise, and I think going back to Karthik's point, today the government is not, I don't think the intent is to per se restrict or deny approvals. I think the idea is to really monitor, and based on the facts of the cases, they may also give more general approvals. And I would at least would want to believe that if you are able to make a case for say a fund structure where the control and others can very easily be demonstrated to be not with with the LPs, but and the GP is not from the restricted zone, you could end up with a composite approval for investments up to a certain level. I think a lot of this will evolve, I think, as we see more and more applications going in, but our experience and idea is that it will be covered under a general approval. Just moving on, I think we've already covered that what additional clarifications are required from on the beneficial owner. So I'll probably skip that one. I think the other question I think, and I think it's an observation as well, that the PN3 seems to kind of discriminate amongst nations. And to the best of my understanding, no particular reasoning is present to support India's action as not being discriminatory against the border nations. Uh, Again, I think, Atul, do you want to take that up, and maybe I'll add a bit to that at the end, but why don't you take a...
So obviously, if we go by the notification as well as the press note which has been issued, the heading is to prevent any hostile takeover, and that is the intention of the government. So government has basically taken a cue from the global development. So if you see in US, specifically in sensitive sectors, there's CFIUS regulations when there is a case-by-case screening in relation to sensitive sectors. Similarly, European Union, Germany, Spain, and a number of countries have basically taken a call in relation to foreign investment which is coming from China or otherwise due to falling valuations. Besides, Australia is also one jurisdiction. So government has been obviously considerate of this, all these developments which had taken place. And obviously, it appears that this is going to be a short-term measure. This is not going to be a permanent feature. This regulation should be there only until this COVID situation gets improved, and thereafter we believe that this notification should be repealed or modified.
No, I agree, and I think just to the point of discrimination, I think from a pure legal perspective, I think that level of discrimination already existed for certain nations, even under our current FDI policies. Investors from Pakistan, Bangladesh, and Nepal were obviously not covered under the automatic, and that already existed. So I think addition of China in itself is not per se creating an additional discretion, because this discretion was always there as a part of our FEMA and FDI policy. So I think that's one added comment over there. I think one question which again is very interesting, and I think all of us are grappling with it, which links to the beneficial owner. Uh, how many layers does one need to kind of keep looking through? I think that is one of
I think Sid, your video
the
was
question
closed.
from the participants. Maybe
Yeah,
I'll
so
just take that, and maybe even have something to add.
Sid, you might want to go on video. I think your video is freezing.
Yeah. So I think okay, I'll turn off the video. So yeah, so the question I think is about how many layers does one need to look through to basically determine the beneficial owner. And I think there, my point is obviously, as I mentioned, beneficial ownership, if the PMLA test is applied, you have to ultimately go back to the person who is in control. And I think it does not have a limitation on number of layers, but at a level that you are able to establish that there is a control by an individual, and to that, and not by ownership, either by ownership or by control, contractual control. I think that level at which you would stop and identify such person as a beneficial owner. So there is no threshold in that sense on the number of layers. On the other hand, for significant beneficial owner, and I think there is a more elaborate definition of SBO under the Companies Act. It basically starts with a low threshold of 10%, but then depending on the entity. So if it's corporate vehicle, then I think the test is applied on the basis that if majority of the shareholding of that entity is owned by a person, then you have to look through that entity. And if not, then you obviously look at that entity as to where does the actual control reside for that entity. And control has been defined in similar fashion in terms of a little subjective on policy decision influence, significant influence on policy decision. Both these tests applying different thresholds, but there is no limitation on number of layers. So I think every structure in that sense will have to be examined to an extent. The good thing is you are already doing this exercise for the purpose. So anyone who has invested in an Indian company, the company is required to file an SBO disclosure. So I think applying that test, you will already have done this exercise, so it may not really be as difficult to determine where the SBO resides. I think just moving on to the other question, I think we've covered the Hong Kong this thing. If there is a change in shareholders in a Hong Kong company being owned by Chinese nationals to another Chinese nationals, and this Hong Kong company has FDI in India, whether an approval will be required in India for transfer of shareholders from one Chinese national to another Chinese national. Karthik, you want to take?
Yeah, I'll take that. So, unfortunately, it will require a prior approval, because the government is saying wherever there's a change in beneficial ownership of a Chinese investor, we want to be kept informed. We want our prior approval taken. So if it's a secondary transaction where, let's say, one Chinese fund is selling to another Chinese fund, or one Chinese FDI buyer is selling to another Chinese FDI buyer, even that will require prior approval. And just keep in mind, this has other ramifications as well. There is no carve out for intra-group transfers. So assume you're part of the same group holding structure, but for tax and other efficiency reasons, you want to move your Indian shareholding around. You want to, let's say, move your Indian shareholding from your Hong Kong company to your Singapore company, both owned by the same Chinese group. Even that intra-group transfer will now require prior approval, because the government wants to know that, look, wherever this Chinese beneficial ownership beyond a certain threshold, we just want to keep track of it. We want to monitor it, and we want, I'm pretty sure in something like an intra-group transfer, the approval will be much easier to obtain. But even in the case of a secondary sale to another Chinese buyer, as long as a cause is made out that, look, we've been investors for a long period of time, this is the best value we are getting. The Chinese buyers who's coming in has this ultimate beneficial ownership. This is a buyer of repute. He has no regulatory actions against him. If you can give those undertakings to the government as part of the approval process, I don't see that really holding up your secondary transaction. But yes, even if, sorry, Siddharth, go ahead.
Yeah, no, so I think again, try to cover as many questions as we can. So I think one of the important question which I think we should respond to is also the fact that whether the press note 3 will apply to any invocation of pledge of shares by a Chinese holder. And I think how would this apply in case of debt? I think maybe Atul, you want to take it up and then maybe Karthik can add on to that.
Yeah, so as such, invocation of pledge should not directly invoke the approval requirements. But yes, in case if there is a beneficial interest, against those that invocation which is going to get attracted when, after invocation, the party is going to acquire certain interest, which would be a beneficial interest or a control or a shareholding, then obviously that would require approval.
Right. From my perspective, I actually don't see it as a significant issue. Most investments into India on the debt side, especially when it's a foreign portfolio investor or it's a hedge fund or fund from Hong Kong or other jurisdiction who gives debt to India, they usually come up with a structure of taking non-convertible debentures. And most of these non-convertible debentures, they have a onshore debenture trustee or security trustee. If there's an invocation of pledge, the debenture trustee or security trustee will hold it for the benefit of the debenture holders. So on the demat account or on the custody account side, the owner will, if there's invocation of the pledge, the owner will be reflected as the debenture trustee stroke security trustee. And in most cases, the minute there's invocation, people tend to sell these pledge securities. So I think the risk of invocation of pledge also being subject to a prior approval is pretty low. It won't be the case because of the typical structures which have been extended for onshore debt financing by foreigners. The use of the debenture trustee, security trustee, will actually mitigate a lot of that risk.
Yeah, so I agree. I think maybe the implication today of these of the press note on NCDs, especially which have come through the FPI route, the argument is that that should not get impacted over here. Second, as Karthik said, the holder of those securities would typically be the security trustee, and hence to that extent with provisions to be built in, I think one could mitigate this risk, except if you are actually satisfying or converting your loans into equity. And this is pretty clearly provided under the ECB guidelines as well. At that stage, it will be treated as an FDI, and hence to that extent, you will definitely require a prior approval for converting any loan into equity. I think that would be how we would look at the question from our perspective. Okay. I think obviously the debate goes on. I think a lot of questions around which definition rely on for the purpose of beneficial owner. And I think, to be honest, today your guess is as good as mine in a way, because I think obviously there is a more push towards the government to use a more lenient threshold of PMLA. And then in many sense, I think there is a logic to say that that should be the threshold ideally if the intent is to primarily cover hostile acquisitions and control. But we also know that there is another school of thought within the government, because they think that we are not looking to kind of curtail or restrict, and our intention is only to know who the beneficial owner is, and hence there is an argument from their end to say whether we should be already complying with the company law SBO definition, then whether that definition itself should not be read into this press note. I think we will see some more clarity, as Karthik said, in a week's time. Just to update you, because there is also related questions about funds and pooling vehicle as to how this test would be applied and what's being represented around that. One of the questions was whether I have funds where I have Chinese LPs who are essentially more than whatever threshold that finally comes out, whether it's 25% or a 10% as per Companies Act. And to that extent, whether those funds would require approval, very clearly, at least based on the current reading, looks like that would be the case. The second situation is where I don't have any of the LPs being the beneficial of breaching this threshold, but I have a manager which is based out of a jurisdiction like Hong Kong. Today, I think, as I kind of alluded to in my previous discussion, because the press note also talks about situated in a restricted jurisdiction. So it is not, so if the manager is in control of the fund, and by virtue of that control, because the BO test also applies control basis, that control is residing in any of the restricted jurisdiction, then again, as per the current reading, there is a requirement for a prior approval. What is being represented by the industry is to say that use a slightly different threshold, and I think the argument is there's going to be a significant need for capital, private equity and venture capital, even more now in the as we come out of the crisis. And to that extent, so long as the intent is not to take over or control entities, and LPs generally do not exercise control over the GP, then I think there should be more leeway given to such pooled investment vehicles. I think the word is still out in terms of whether the government will buy into it or will want to still continue, but we are hopeful that government will do investment vehicles slightly differently than maybe other strategic investments. I know we're kind of running out of time on this. I think one of the questions, Atul, for you, I think a lot has been talked about the approval process. I mean, do you want to shed some light in terms of do you see this approval process really get implemented by the government, and which is the authority which will be responsible for giving such approval?
Sure. So, if you recall, there was a Foreign Investment Promotion Board until 2015, which used to process all the FDI applications earlier. But after abolition of FIPB, government issued a standard operating procedure note when all the powers with respect to any investment coming in a particular sector has been given to the nodal ministries. So, for example, if an investment is coming in the pharma sector, it will be decided by Department of Pharma. Similarly, if an investment is coming in, say, retail sector, it will be decided by DIPP and so on and so forth. But the process would be that we have to make an online filing on the FIFP portal, which is Foreign Investment Promotion Portal, which is being managed by DPIIT. And then DPIIT basically forwards the application to the concerned nodal ministry. For example, as I mentioned, pharma sector to Department of Pharma. And then accordingly, internally, they will collate comments and obviously ask for information with respect to the target company, the investors, their financial statements, constitutional documents, valuation certificate, similarly investment agreement, term sheet, etc. So these kind of questions as well as documents are generally asked for. And obviously, in some of the sensitive sectors, we also anticipate that Ministry of Home Affairs security clearance may also be required. So basically, this is the process, and once all this information is being collated by the concerned nodal ministry, they accordingly issue the approval letter. Again, just to because we have started helping a number of Chinese companies and investors in this process since the issuance of FEMA notification already, and the only thing which is to be considered as of now, government is definitely thinking of bifurcating sensitive vis-a-vis non-sensitive sectors, as all of us are anticipating. So far as non-sensitive sectors are concerned, or companies which are already in control of Chinese investors or 100% wholly owned subsidiaries of Chinese companies, we think that there would not be many layer of bureaucratic approvals internally, and accordingly approvals in such cases may come quite faster.
No, I think that's true, and I think we have been given some assurances in our engagement with the government that they will put in place a time-bound and a process, clearly laid out process for such approvals. And we do hope that the approval route would not become a significant hindrance, even where investors are likely to get caught into the deflation. So I think, and I think also how one seeks that approval, especially for pooled investment vehicle, can a blanket approval up to giving certain comfort to the government can be obtained. I think a lot of that will be a tactical approach which we should kind of carefully evaluate going forward. And there may be an option to kind of mitigate or make the process a little smoother as well.
Yeah, just to add, Sid,
Please.
yeah, there are precedents with respect to omnibus approval also. So say, for example, different tranches of investment have to come in future, then government has in past given such approvals for second or third or fourth round of tranches, in the first application itself. So one can always consider of taking an omnibus approval, and obviously it would be on a non-committal basis. So tomorrow, in case if investor decides not to make such infusion, then there would not be any, say, a mandatory requirement for them to, or they would not be treated in violation of the approval letter or the FDI policy.
Right. Okay. No, I think that's very valid, and I think Karthik, just maybe one more question, because I think we have run out of time on this, and just for the participants, I think we will be happy to share. I think there's been a lot of requests for the presentation to be shared, so I think we will be kind of happy to share that. And then of course, if you have any more follow-up questions, maybe one last question with respect to your existing rights, and I think exit right you did touch upon, I think on the put options an investor. Of course, how would this be impacted in one sense? And secondly, also, what are the rights? I mean, how would this impact some of the other instruments, such as CCPS, CCDs, or even partly paid up shares, and whether the obligation to make up for the payment as per the terms of the instrument, what would that also get covered under the ambit of this press note?
Okay, thank you, Sid. Sid, I'll go instrument by instrument. So if you had an instrument which was a convertible, and obviously convertibles are very, very popular in India, especially on a Series A, Series B, Series C term sheets. There, 99% chances are there will always be a convertible instrument in there. For convertibles which have already been issued, there is no prior approval now required to convert those convertibles into equity shares. And the reason for that is because at the time the convertibles were issued, a regulatory filing was already made by the issuer with the RBI, the Reserve Bank of India, indicating what convertibles were issued, what the conversion ratios were, what the conversion formulas were. So that piece was already taken care of. So this is an instrument which is grandfathered. At the time you convert into equity, the new press note will not bother you, because these are already registered instruments and these are already disclosed and approved in instruments. So if it's a party paid share, it's a convertible instrument. Convertible instruments typically don't require you to bring in further funds, except if it's a party paid instrument or it's a warrant, in which case you may have to bring further funds in the future. But again, because those instruments have already been issued under the previous policy without government approvals, it's par for the course. There's no requirement for any new approvals in those cases. So for convertibles, I would say just hold on to your horses. Nothing to be done. The document works. Your existing documents are designed to work in a manner which does not require prior approval, including any ratchets, etc., any reset in conversion terms. The other issue which comes up is on exits. So assume you were to exit via an IPO. Again, any exit via an IPO, via an offer for sale mechanism as part of the IPO or the public offer process, that does not require any prior approval, because again, you are in effect divesting, you're not making any new investments. So the circular's ambit does not apply to you. On the question of put options, if you have, let's say, a guaranteed put, or if you have some kind of return framework or some kind of buyback obligation, again, this policy will not apply to you, because this is not new investments. You're just giving effect to an already agreed contractual exit right. So obviously you could expect in some cases, maybe issuers who don't want to honor the obligations may want to bring the circular up, etc., or raise issues around the circular. But I don't think any of those defenses would be tenable, because any exit right which you negotiated are not caught within the ambit of this new policy. This new policy, just to be clear, is only for new investments into India. It doesn't apply to anything you already have, and that to any new investments under the FDI route. All other routes, there are no prior approval required.
Right. So, no, I think thanks a lot, Karthik, and I think with that I'd like to thank all the participants here. I think we have tried to cover as many questions because while we tried to do that as a part of the presentation as well, but I think if there are still unanswered questions, we will definitely attempt to respond to those questions. But I think where we stand today, just to conclude, I think the press note is here to stay. I think you need to kind of start thinking about how to address your situation. And I think we are, as Atul and Karthik mentioned, we are already working with a lot of clients to kind of assess their situation about in terms of whether the need for approval or otherwise. And then secondly, also strategize well in advance, because as Atul mentioned, there may be an option for omnibus approvals. So I think a lot of those can be kind of thought through as we wait for more clarity around the beneficial ownership. But I'm sure we'll keep you all posted on that. And with that, would like to thank once again all the participants for taking out time. We do hope that this session would give you some perspective and some clarity. And we look forward to staying in touch with all of you. Thank you and goodbye from Khaitan, and please do take care and stay safe. Thank you.
Thank you.